Yep, you got Harrington here. All right, folks, let's pick up on our discussion from last week. I just feel like we left a little too much meat on the bones. We were talking property law. In particular, we touched on a couple of deeds. We ended up talking about a ladybird deed, and I want to kind of segue from there. Now, these are 10-minute videos. I'm not going to be able to turn you guys into title examiners, but I can fill in a few gaps that I left from last week. So here we go. Our Practice Makes Perfect is the podcast for business owners and real estate investors, siempre con un cariño especial para los clientes extranjeros. Part 1. Buy the entireties. What is that? All right, well, let's start with the example of a married couple because here in Florida, that's really the only way you can do it. And in some states, like in California, for example, this concept's not even recognized at all. We're talking about the situation where both spouses are named on the deed, and when that happens, the property is presumed to be owned by the entireties. And you don't have to do anything special to make that happen. It's not like homestead where you need to register with the county. It's the presumption. So what that means in our example is that the two spouses don't own the property 50-50 or any other kind of split. Both spouses are 100% owners of the entire property. That's by the entirety. I know metaphysically that's just slightly mysterious, right? How can it be that two people both own 100% of the same item? But here in Florida, we go with that legal fiction. Now, the moment you divorce, you do then go to a 50-50 split or whatever the divorce decree says. So you lose that by the entirety's ownership. Now, why would I say lose as though that's a bad thing? Well, it's because there are some advantages to owning property by the entireties. In particular, it's an asset protection technique. So let's say, for example, that one of the spouses has a creditor or is being sued by somebody. Well, that party, that creditor, won't be able to touch any assets that are owned by the entireties. That goes for bank accounts too, at least here in Florida. Another good example is this, bankruptcy, again, here in Florida. In the case of one spouse that declares bankruptcy, probably the spouses have their money together in one joint account. The trustee can't get to that account if it's owned by the entireties, nor any investment properties that are owned by the entireties. You get what I mean? And that can be very handy, as you can imagine. So, if your spouse gets into financial trouble, you don't want the bankruptcy trustee or the creditor taking the money in your joint account, like your money or your percentage of the property that you guys own jointly. It's a nice protection to have, right? In addition to asset protection, ownership by the entireties can also simplify succession, and that brings me to my next point. Point number 2, right of survivorship. Okay, we were talking about succession. Well, in the case of a property that's owned by the entireties, there's really no issue. If one spouse dies, well, the other spouse continues to be the 100% now sole owner of that property. There's no need to do anything. The spouse that dies will drop off the deed. The one that survives remains on the deed. It just happens automatically as an operation of law. Now, however, if you want to change that result, which sometimes you may, then you will have to take some extra measures. So let's say, for example, that this is a second marriage and the spouse that passed away intended for his or her children to receive his or her interest in the property rather than the property going automatically to the new spouse. Well, if the decedent is married to the new spouse and they're both on title, well, then that presumption is going to kick in. And so if that's not what you want, you're going to have to do something about it before you die. And if you do want your interest in the property to go to your kids rather than your spouse, that doesn't make you a bad person. There are plenty of situations where that just feels like the right thing to do. Let's say, for example, you haven't been married all that long. You had paid off all or most of the property before getting married to your new spouse. Maybe your kids grew up in the property. You see what I mean? There are situations where it feels like the kid should inherit at least some portion of the property. Now, remember what we talked about last episode, the so-called ladybird deed. I guess they go with ladybird because you gals tend to outlast us. And guys, maybe we need to try a little harder. This is a little embarrassing. They just assume we're going first. Anyway, the surviving spouse, a woman or a man, could sign a deed saying, I get to live in this property for as long as I'm alive, and then when I'm gone, it goes to the kids. That could be a fair solution. Or maybe that could not be a fair solution. Like, say, if the new spouse is much younger than the decedent. The kids might be like, hey, she could outlive all of us. Well, in that case, the deed may require some special wording, but the phrase you want to know is right of survivorship. Let me give you an example, and let's make this an investment property because that then avoids the homestead complications. Actually, this is a good place for me to insert a quick disclaimer. Guys, these are very short videos. I can't cover all the possible factors in play, like, for example, the homestead rights under the Florida Constitution, which could change the result altogether. So, I'm just trying to give you guys some general concepts. Be very careful about running out and writing up your own deeds. But back to our example. This is an investment property, and the husband is not going to put the new wife on the title because the moment he does, then the by the entireties presumption kicks in. So instead, it's going to be the husband along with his kids who have a right of survivorship. With that language in place, when Pop kicks off, then the kids automatically inherit the property. There's no need for anything to happen. Again, it's just by operation of law. And that brings us to point number 3, the life estate deed. Last episode, we discussed the enhanced life estate deed, which is referred to commonly as the somewhat sexist and ladies, frankly, just a little presumptuous, so-called ladybird deed. Now, the enhanced aspect is the right to not only live in the property, but do whatever you want with the property. So including rent it or even sell it. So let's say that you're the ladybird. Well, even though you have named your successor, you preserve all your rights. It's still your property, basically. You can do whatever you want. By contrast, with a regular traditional life estate deed, you don't have that right. If you're going to, say, for example, sell the property, well, then your named successor will have to sign off on that. Let that swirl around just a bit. There is some gamesmanship involved. So that's it for today, guys. That's just a taste of property law, dreaded by many law school students because it can get quite hairy. But these are very important concepts to be aware of. I mean, if we're talking about property, then we're usually talking about hundreds of thousands of dollars. So it's good to know at least a little something about it. But that's it for today. Recuerda que hablamos español. You know, to do the honorable thing with the likes and the shares. Oh, thanks, by the way, you guys. I'm getting a lot more comments and people engaging me on these posts. So thank you so much for that. I appreciate it. And I will see you next week.